Welcome to the Equal Opportunities Committee, the 25th meeting of 2013. Please set any electronic devices to flight mode or off, please. I'd like to start by asking everyone to introduce themselves. At the table we have our clerking and research team together with official reporters. Around the room we are supported by Broadcasting Services and the Security Office, and welcome to the observers in the public gallery. My name is Margaret McCulloch and I'm the committee convener, and I now invite members to introduce themselves in turn, starting here on my right.
I'm Marco Biaggi. I'm the deputy convener of the committee and the MSP for Edinburgh Central.
Morning, John Finney, MSP Highlands and Islands.
Good morning, Christian Allard, MSP for the North East of Scotland.
Morning, Siobhan McMahon, MSP Central Scotland.
Alec Johnston, member from North East Scotland.
John Mason, MSP for Glasgow Shettleston.
The first agenda item today is a decision on taking business in private. You're asked to agree to take consideration of a draft report on the Marriage and Civil Partnership Scotland Bill at stage 1 in private at this meeting and at future meetings. Are we all agreed? Yes. Thank you. That's agreed. The second item is ministerial evidence on the Marriage and Civil Partnership Scotland Bill at stage 1. Can I start by asking the Minister and officials to introduce themselves and invite the Minister to make his opening remarks?
I'll introduce myself first. Convener, Alec Neil, MSP Cabinet Secretary for Health and Wellbeing, and on behalf of the Government I'm leading on this bill.
I'm Francesca Morton from the Scottish Government Legal Directorate.
Morning, my name is Julia McCombie. I'm from the Family and Property Law team in the Scottish Government.
Morning, I'm Simon Stockwell, Family and Property Law team, Scottish Government.
Thank you very much. Can I also remind members to address questions through the chair? The first question I would like to ask the Cabinet Secretary is, the Law Society notes that the bill will expand the way in which couples can choose to define their relationship, whether different or same-sex marriage, cohabitation or civil partnership. It suggests that in order to help people to understand the differences between them and or choose between them, further definition or explanation of the status of each would be useful. Could we have your comments, please?
Can I say, Convener, I had an opening statement, if that was okay.
I apologise. Yes, sorry.
Can I do that first?
You certainly
please?
can.
Okay.
I
Thank you very much indeed. Thank you. I didn't want to interrupt you. Can I, first of all, thank the committee for the opportunity to come before you start to prepare your Stage 1 report on the principles of this bill. And can I say, Convener, I do promise unusually to be as brief and concise as I possibly can be. This bill is essentially about addressing an inequality that currently exists for lesbian, gay, bisexual and transgender people. The bill provides the option for same-sex couples to marry and for the registration of religious and belief civil partnerships. This bill will also impact significantly on transgender people. A couple who is already married will no longer have to divorce, as is current practice, before the transgender person can obtain a full gender recognition certificate. In passing this legislation, the Scottish Parliament will be taking a significant step to reduce inequality. However, this government also recognises the challenges this legislation presents to those who consider that marriage should remain a union between one man and one woman. We understand the concerns they have, and that is why we've included strong protections for religious and belief bodies and celebrants in the bill, including an opt-in process for the religious or belief body and the individual celebrant before any solemnisation of a same-sex marriage can take place. We have also agreed with the UK Government that there will be amendments to the Equality Act. The bill also contains a provision on freedom of speech, and the Lord Advocate has already produced prosecution guidance on this matter. My colleague Mike Russell, the Education Secretary, is currently seeking views on draft guidance which reaffirms the rights of parents to opt children out of sexual health education classes. Marriage is a key societal issue, and this bill has attracted a great deal of interest and criticism. We have worked hard to balance everyone's rights within the bill. I have followed the evidence from the earlier sessions with great interest, and I welcome your questions. Thank you.
Would you like me to repeat my question? The Law Society notes that the bill will expand the ways in which a couple can choose to define their relationship, whether different or same-sex marriage, cohabitation or civil partnership. It suggests that in order to help people to understand the differences between them and or choose between them, further definition or explanation of the status of each would be useful.
Thank you, Convener. My view is actually, if and when this bill passes, then we will have sufficient definition. It's very clear in Scots law about cohabitation, and there's a lot of case law obviously involved in cohabitation. We have defined very clearly in previous legislation about 8 years ago the definition of civil partnerships, and this bill very clearly defines same-sex marriage. Now, the one outstanding area, of course, is the issue of whether the civil partnership should be extended to mixed-sex couples and not confined to same-sex couples. And as you know, we've announced a review on that matter, which will also run concomitantly with the review undertaken by the UK government. And the reason for that, as I'll no doubt explain later when we get to this issue, is because a lot of the issues that have to be considered, and this would require future legislation, there wouldn't be time to do it in this bill, a lot of the issues around that relate to reserve matters, in particular issues around pensions. So my view is that if and when this bill passes, we will then have very clear definitions in Scots law. And of course, cohabitation in Scotland is recognised in a way in law that it's not recognised south of the border, but we'll have cohabitation, we'll have civil partnership, and we'll have marriage, including same-sex marriage. And my view is the definitions then will be very clear indeed.
Thank you very much. Witnesses against the bill also have concerns that redefining marriage beyond simply one man, one woman, it could open marriage to further redefinitions in future. Does making a change to the definition of marriage now potentially allow for further redefinition at a later stage?
Well, you know, we live in a democracy. My view is that this is an overdue reform of the law, but I don't envisage any further reforms to, as it's described, the definition of marriage in terms of who can enter into a marriage legally in Scotland. So my view is that once this bill passes, then quite frankly, we as a government certainly have no intention of introducing further legislation to amend marriage legislation in the future.
What would be the Scottish Government's response to witnesses who have argued that the bill actually weakens or diminishes the institution of marriage?
I've been married for 35 years, and I don't feel personally that allowing people of the same sex to be married in any way diminishes my marriage, quite frankly. Now, I know there are some people who feel that. I think people who feel that tend to think of that more from a religious point of view than necessarily from a legal point of view. Now, what this bill does is recognise marriage between same-sex couples in law. It's entirely up to individual churches and celebrants to decide, you know, from a religious point of view, what their approach is, and that has to be obviously respected. But actually, in many ways, my view is that it actually enhances marriage, because then the issue of equality that I referred to in my introductory remarks is then satisfied. And I do think it is unfair that people who are in love and are of the same sex and who wish to marry, that currently they are banned from doing so. And of course, we'll get some institutions like the Quaker Church who actually, one of the reasons they're in favour of this change in the law is because they themselves believe that same-sex couples should be, certainly in their church, allowed to marry, as well as legally in terms of their church. So at the moment, the law bans, for example, the Quaker Church from doing what the Quaker Church would like to do, which is to administer same-sex marriages.
Thank you very much. John Mason would like to come in.
Yes, now kind of supplementary, I mean, the term definition of marriage has been used, or define marriage. Is there a definition for marriage, or can you define marriage?
Well, there's clearly a definition in law, John, and there's a definition in each church about the union between a man and a woman and what rights and responsibilities is carried by marriage. But what this bill does is, the one change it makes is that it allows marriage to take place between two people of the same sex, whereas at the moment, under current legislation, a marriage in law in Scotland can only take place between one man and one woman.
I'm not sure that's really a definition, but I mean, if the definition, I mean, you used the phrase yourself and others have used it, if people are in love with each other, that should allow marriage. So, I mean, by the same logic, two people who are closely related of the same sex could presumably be married. And in fact, as long as they were willing, 3 people could be married if they all love each other.
Well, let's confine ourselves to the provisions, first of all, of this bill. This bill is, in terms of marriage, is doing one thing and one thing only, and that is that it's allowing people of the same sex to marry. The wider issues about defining marriage, about other issues related to marriage, are not the subject of this bill. The bill deals with this one change and the consequences arising from that change and that change only. Any other issues around the definition of marriage would require additional legislation, and we've got no plans at the moment to introduce any additional legislation around the definition of marriage.
Alex Johnson.
Thank you, Convener. We're certainly redefining marriage with this piece of legislation, but when the Minister spoke in his opening remarks, he concentrated heavily on the issue of equality. And I wonder if perhaps we're maybe also redefining the equality with this legislation. Now, if I was entitled to do something and someone else was forbidden by law from doing that because of the colour of their skin or their sex, I think that would be a fundamental equalities issue. What we're talking about here is slightly different in that the rights that I have and the rights that everybody else has, whatever they may be, are in fact identical. So we have, in effect, a degree of equality here. Do you think that the term equality, as you used it in your opening remarks, requires a reinterpretation of what we mean by equality?
No, I think this bill deals very specific with what I would regard as an inequality, and that is the right of people of the same sex to marry and have that marriage legally recognised in Scotland. That is the inequality that we are rectifying in this legislation.
Just to recap on that, we're giving someone a right, or giving people a right that they didn't previously have, but the people who will require that right have always had an equality of rights under the law. They're the same rights that I had and the same rights that you had. Are we defining equality in a different way in this bill from what we've used in previous legislation?
You're right up to the point, Alec, in the sense that people who are gay have the same rights as you and me in most other, in fact, I think in all other aspects, with some maybe possible exceptions, but generally speaking, the same rights as you and I. The one right at the moment they don't have is the right to marry someone else who is of the same sex. And what this bill does, it closes that gap to make sure that that part of equality is satisfied. Those people who wish to marry, who are of the same sex, are allowed to do so. This bill is not forcing anybody to do anything. All it does is give people more freedoms. It gives the people who are of the same sex who wish to marry the freedom to marry in law. It gives, however, the freedom of churches who wish to carry out same-sex marriages to do so. They're not allowed to do so at the moment, so they will have the freedom to do so according to their religious beliefs. Similarly, along with the amendments to the Equality Act, the UK Equality Act, is an opt-in piece of legislation, and there are guarantees for those organisations and churches and celebrants who do not wish to solemnise same-sex marriages, or indeed, in religious terms, to recognise same-sex marriages. So this is, I think, a fundamental issue about equality and freedom, because at the moment the current legislation restricts personal freedom. It restricts the personal freedom of people of the same sex to marry, and it restricts the freedom of Quakers, for example, to administer same-sex marriages. So we're now giving individuals, and in the case, say, of the Quaker Church and other churches, albeit a minority of churches, the freedom to carry out same-sex marriages, which is what they wish to do.
I would suggest that much of the law is about defining and restricting personal freedom, but
sometimes the law is about expanding freedom. This law is about expanding freedom.
Would any other members like to come in on this issue? No. Thank you. We'll move on to Marco Biagi.
Thank you, Convener. You've already referred to the forthcoming review of civil partnerships. Can you give us any kind of indication what the time frame on that will be?
Well, I would hope to have it done reasonably speedily. The issue here for us in terms of timing, and why I haven't put a deadline on it, is that I think it would make sense for our review, which is of course started, and you've published the remit of the review. But I don't believe our review can be totally completed until we see the conclusions and recommendations from the UK government's review. And the reason for that is many of the issues which will inform both reviews are on reserved matters, particularly around pensions and the like. And therefore, I think it would be sensible for our review to have the opportunity to study the recommendations and conclusions from the UK review, but in consultation with Maria Miller, the Culture Secretary, who's the lead minister for this in the UK Cabinet, I've agreed with her that we want to try and get this done and dusted reasonably quickly. We need to do it properly and thoroughly, and it will be into 2014, but, the sooner it's done, the better, in my view.
With regard to the review and the possibility of opening civil partnerships to mixed-sex couples, is the government currently on the central principle of that, minded one way or the other, or is it still undecided and awaiting the evidence from the stakeholders?
So the government has no policy. We're going to wait and see what the review says and then decide what our policy should be.
Are you aware of the case in front of the European courts at the moment regarding 4 mixed-sex couples seeking the right to enter a civil partnership? We've heard some views of this in evidence. Is this something that the government is conscious of with regard to the review?
We're always conscious of what happens in the European Court, and our position is on that particular issue, we will wait to see what the court says, and if it requires any action by us, we'll then consider that, obviously. But I think it would be appropriate, given that this is before the courts in Europe, for us to wait and see what the court actually says.
And the sort of mirror image of the couple that are married where one transitions gender and having to divorce is the couple in a civil partnership where one transitions gender and they have to dissolve. Is that something that will be addressed as well in the process of the review? Because that will be quite a glaring anomaly right now.
I mean, the remit's wide enough for the review to look at these issues, obviously, because clearly that, I suspect in the evidence to the review that that issue will be featuring.
Another point on civil partnerships that's come up is the difficulty for people who have a foreign civil partnership to enter into a same-sex marriage here in Scotland without dissolving it in their home jurisdiction. And it's a difficulty compared to what they could do if they had a Scottish civil partnership and they wanted to change that through the administrative process to marriage. Is that something the government is aware of from the submissions and from dealing with stakeholders, and is that something the government intends to look at again in the passage of the bill?
Well, we really are not inclined to come forward with any amendments in that respect of that question, and it's out of respect for other jurisdictions, for foreign jurisdictions, because when you look at the law in other jurisdictions, it could cause enormous complications, particularly if there's a dissolution proposed of the civil partnership, or if it goes on to a marriage, the dissolution of the marriage in some way. So in terms of complications, it would make the law very, very complicated if we tried to address the intricacies of that. We think it's much more straightforward and would not delay the passage of this bill for us to not come forward with any amendments to our position on that. If someone comes from abroad to live in Scotland and they're in a civil partnership, then obviously they would be free to marry in Scotland, I think I'm right in saying. No. If they're from abroad, even if there's a civil partnership, they're free to marry.
We would recognise a civil partnership.
Yes, right. We'd recognise a civil partnership. Yeah, sorry. Simon's much more au fait with the detail intricacy than I am.
You get quite into some detailed bits of drafting there.
Yeah, go for it. Can I bring Siobhan McMahon on this issue in?
Okay, just to follow up on Marco's point about the current challenge in the European Court, you'll be aware that Article 8 is engaged of the Human Rights Act, meaning that the bill could currently be seen as discriminating against mixed-sex couples. I was just wondering why we have to take the review and why actually, when we were discussing this bill, and given it's a matter of equality, that wasn't included in the first place. Was there a reason for that?
See, the premise of the question, we would dispute that this bill could be seen as discriminating against mixed-sex couples because we absolutely do not accept that interpretation either of our law or of the European Convention on Human Rights. So the premise of the question, I think, is
Any evidence from lawyers that had said that was the case?
The Scottish
it's not my personal view, it's law.
The Scottish Government position is very clear, and that is that this bill is not in contravention of the rights of mixed-sex couples.
Okay, but given that we've heard the legal evidence on that, again, can you explain why you never thought to include it in this bill, given that the review is taking place, that you're minded to look at it in the future, and given that it could, as we've heard, that it could be engaged, why it wasn't included, why the review is taking place now, and if it were to be engaged, and obviously we'll have to wait and see what happens in the European Court, but do you think that it should be amended in this current bill, and that we should wait for the evidence on that?
Get married, so we don't see a need to amend this bill. But I'll ask Simon to go into a bit more detail on the intricacies of this, Siobhan.
I mean, the Cabinet Secretary has explained quite a lot of the issues already, that clearly we would need to reach agreement with the UK Government on a number of the reserved matters in relation to opposite-sex civil partnerships. When we've looked at this in the past, one of the big questions has been, well, you could enter into an opposite-sex civil partnership in Scotland, but what rights and responsibilities would it give you for reserved matters within Scotland, or indeed if you travelled outside Scotland as well? There's no guarantee, for example, if you entered into an opposite-sex civil partnership, that you'd be able to bring in your partner from overseas, because there's no guarantee the UK Government would recognise it for immigration purposes in the same way as they recognise a civil partner or a married person, a same-sex civil partner or a married person. There's other issues in relation to social security as well, and as the Cabinet Secretary mentioned, pensions. So very much we would have to work with the UK Government on what are the implications for reserved matters as well as devolved, because otherwise you could find that a couple enter into a mixed-sex civil partnership, think they've got full rights and responsibilities, and actually they wouldn't have necessarily. They have quite limited rights and responsibilities, unless, as the Cabinet Secretary said, the reserved matters followed as well.
Just to make clear, the reason it wasn't included in this bill is because mixed-sex couples currently can get married, so not that they've been denied a civil partnership.
No, I think it would make this bill much more complicated, and there's a lot of ramifications, and quite frankly, as Simon has just outlined, without moving in concert with our colleagues south of the border, it could cause a lot of problems, actually, rather than solve problems. So our view is the sensible thing to do with this whole issue is for us to work with our colleagues south of the border, take our time, and hopefully by sometime next year get into a position where we are very cognizant of all the challenges that would be faced by that particular change in the legislation, and then a decision has to be made both south of the border and north of the border as to whether we then go ahead with any recommendations resulting from the two reviews.
Thank you. Can I just ask the Cabinet Secretary a question? Civil partnerships performed abroad can be dissolved in Scotland? Yes.
Yes.
Polygamous marriages in Saudi, for example, where it's legal, I assume, can also be dissolved in Scotland? Yeah. That being the case, can you tell me why then a civil partnership from abroad then has to actually dissolve the marriage, dissolve the relationship and separate for a year before they can then get married?
I'll ask Francesca to explain that one from a legal point of view.
When you say they have to dissolve and separate for a year, that's because of the obligations in terms of the...
Yeah.
That falls back on the position of the policy that it's only marriages which are registered or solemnised in Scotland which will be, under the bill, permitted to change to a marriage. Did I say civil partnership? Yes, what I mean is only civil partnerships which are registered in Scotland will be permitted to change to a marriage under the changing provisions in the bill. So that's that's why that's the position in terms of overseas civil partnerships.
Vina, there are, I mean, we have looked at this question of overseas civil partnerships changing to a marriage in Scotland, and Cabinet Secretary gave some of the reasons why we think it's difficult. Perhaps I could outline some more of the reasons. First of all, as the Cabinet Secretary said, there is an issue about respect for overseas jurisdictions. When we've looked at what other jurisdictions do in respect of changing overseas civil partnerships to marriages, some of them do and some of them don't, is the short position. It seems to be the case that in Holland and in New Zealand they would change overseas civil partnerships to marriages, whereas Norway and Sweden would not. Certainly in Holland, for example, you've got to be either resident in Holland or you've got to be a Dutch national in order to get married in Holland. And that's not the case in Scotland. In Scotland, pretty well anybody can come here and get married. So if we introduce a residence requirement for civil partners changing their relationship to marriage in Scotland, that would be unusual in Scots marriage law. It's not impossible, but it would certainly distinguish between most people getting married and people changing their civil partnership to marriage. There might have to be a residence requirement for these people. Obviously, the English have got their own provision in the UK Act, so there's probably no need to look at English civil partnerships because they've got provision within their own Act. There's also a question about when would we say the marriage would have deemed to have started. At the moment, in the Scottish Bill as it stands, we've got provision which says that if you change your civil partnership to a marriage, the marriage is deemed to have started when you entered into the civil partnership. It might be hard for us to do that in respect to the overseas jurisdiction because we don't have the same sort of control over civil partnerships registered in overseas jurisdictions as we do in Scotland. So there are, we think, a number of sort of quite complicated issues we'd need to go through really before we thought about changing overseas civil partnerships to marriage within Scotland.
Finally, is that something that you will consider for the future?
Well, we'll see what comes. You know, these issues may well be raised during the review. The remit's wide enough to take these on board, and that's why you can see the complications. This is not a straightforward process, and it needs a lot of consultation. It needs a lot of research before we can decide the best way forward. But there's no reason why the review in civil partnerships could not consider these issues.
Yes, definitely.
I'd like to ask you now about the pension policy regarding same-sex spouses. The pension policy is reserved, and I know you mentioned that in your introduction, but there are devolved powers on pension policy relating to certain public sector schemes. Why does the Scottish Government then intend to treat same-sex spouses in the same way as civil partners for the pension scheme, where the Scottish Government has the devolved responsibility?
Well, as a general principle in terms of pensions, irrespective of the provisions of this particular bill, the policy of the Scottish Government, where we do have devolved responsibility, is as far as possible is to approach pensions policy which is compatible with the general principles of pensions policy across the UK, because to do otherwise would result in so many potential anomalies and difficulties. So that's our general approach. However, at the moment, there is a review being undertaken by the UK Government in terms particularly of occupational pensions, and that will report, we reckon, around about July next year. Now, once we see the results of that review, then we can discuss with our colleagues south of the border, or of course, depending on what happens on the 18th of September next year, we might be able to take the decision ourselves, I would hope, in terms of the future of pensions policy in this respect. We are very conscious of the issue. We have an open mind about it, and we think that the sensible thing to do would be to await the review of the occupational pensions review, which is undertaken by the UK Government, because that, I think, will give us a very clear indication of the best way forward in this area.
Very much. Does any other member want to ask any questions relating to this? No. Can we now move on to transgender provisions? And John Finney would like to ask you questions.
Thank you, Convener. Morning, Cabinet Secretary. Cabinet Secretary, you talked about this legislation impacting significantly on a group of people, and I would like to raise a number of issues around the implications for transgender people, and particularly what's been referred to as a spousal veto. And to try and understand how you see any merit in requiring a declaration of spousal consent to continue with the issuing of a gender reassignment certificate, please.
I see we obviously recognise the concerns here, because it is quite a difficult issue for us. Spousal consent is not required to obtain a new gender. I think that's the first point to stress. The consent is required to stay in the marriage when a new gender is acquired. Both parties must, of course, be willing to stay in the marriage, and the bill, in the bill, we've recognised the specific concern that some non-transitioning spouses may not wish to be in a same-sex marriage after the spouse obtains gender recognition. Now, I know the point's been raised that the non-transitioning spouse has at least 2 years to take action, given that the transitioning spouse must live in the acquired gender for 2 years before applying to the gender recognition panel. However, it may be the application to the panel that makes a non-transitioning spouse consider his or her options. So, again, it's quite a complicated area, but we've been listening to the concerns, and we believe that we're addressing those concerns. But if the committee, in its report, wants to make any recommendations, we would obviously listen to what the committee had to say.
I think the options available to the spouse during that 2-year period are the thing that gives rise to a lot of concern, and it's seen as, if you like, being punitive on their part with regard to the other individual. But perhaps the committee will put...
The committee wants to comment on that. We'll certainly take into very serious consideration the committee's view.
Thanks very much. On the term and the issue of evidence requirements for those who are long-term transitioned over 6 years, it can be quite difficult for those individuals to assemble the same level of evidence as others. Is that something that you could look at?
I'm going to ask Simon to deal with this one, because it's, again, quite an intricate, some technical issues involved here that I think Simon can explain in some detail to you, John.
The short answer is yes. The UK bill, or the UK Act rather, is on very similar lines to our bill in this area, and that was deliberate because the Gender Recognition Panel operates on a UK basis, and we wanted to stay as far as possible in line with the way in which the Gender Recognition Panel operates. The UK government decided, after speaking to us, to amend their bill at quite a late stage to introduce what is sometimes called fast track for long-term transition people who possibly can't get the full range of medical evidence. The UK Act obviously relates to people who couldn't use the original fast track. There was a fast track in the original Gender Recognition Act when it was put forward, and the UK Act relates to people who couldn't use that because they didn't want to end their marriage. Now, we're thinking that at stage 2 we might lodge a very similar amendment along similar lines to what's already in the UK bill to try and address that issue. We'll have some detailed discussions with the Equality Network and the Scottish Transgender Alliance, because I know they're putting forward some proposals in this area, and we've seen what they proposed. And also we will speak to the UK government and the Gender Recognition Panel, given that, as I say, the Gender Recognition Panel operates on a UK basis. But in principle, yes, we think there is some scope to introduce an amendment here at stage 2.
And again, we would welcome the committee's convener, the committee's views on this matter, because obviously it's been raised with you, and your views we will certainly take into serious consideration in deciding what stage 2 amendments to bring forward.
That's very reassuring. Can I ask the question of language and gender-neutral language, as has been referred to, the use of that in ceremonies, Cabinet Secretary?
Sorry, in which way, John?
Gender-neutral language, so rather than husband and wife, for instance, spouse might be the term that would be used.
Well, we think we've probably reached a kind of right balance in that. But again, we're willing to... this is a very sensitive issue, obviously. And, I think there are some areas where you want to take a kind of licentious approach to this, and other areas where you need to be very clear in terms of your definitions. The proposal, both, as I understand the proposal, both the denomination and the couple would have to agree to use the gender-neutral declaration. This might add further detail to the arrangements for the ceremonies. I would not rule out change altogether on this, and again, we'll listen to what the committee has to say, but I am concerned about the complexity here, and obviously any further changes to the bill in this respect would require a great deal of thought, because it's not so much the amendment itself that might come forward, or amendments, it's the implications and unintended consequences of any potential amendment. So we would welcome comments from the committee, but it's an area we will be quite cautious about, simply because this is a particularly complex area, And I don't want to end up with unintended consequences, particularly if it damages the people that we're trying to support in terms of moving forward.
I think perhaps the other point to make there as well is that we'd want to make certain that we weren't causing any problems for denominations who might not necessarily want to use a gender-neutral marriage declaration when they're marrying an opposite-sex couple. We would need to speak to them as well.
But just to clarify, it's a live issue. It's something you're
and again, you know, if the committee wants to comment on that, we'll certainly take into consideration. We've obviously very much aware of the evidence, both oral evidence and written evidence that's been given to the committee. We're looking at all of that anyway, but what will primarily inform my view about what amendments to bring forward at stage 2 will be the committee's comments on this.
a couple of other that perhaps seen as a bit technical, again, Cabinet Secretary, and relating to those wishing to cohabit after receiving a gender recognition certificate. What protections will the bill offer them from losing their accrued rights and entitlements?
Is this the scenario that the couple decide to divorce anyway because they decide they can't live in a same-sex marriage? In essence, what we've concluded here is that the bill is providing people with considerable rights. The bill is allowing transgender people to stay married and obtain gender recognition so long as to stay in the marriage they've got the consent of the spouse. The bill is also allowing a civil partner to change that relationship to a marriage and acquire gender recognition. So we think there is considerable vision in the bill to allow gender recognition to take place and allow people to stay married or change their civil partnership to a marriage. We don't think, therefore, that we need any further provision because, in essence, we think if a couple decide to divorce or decide to dissolve, then really that is their choice now, and it's very similar to any other couple who decide to divorce or dissolve. So we're not looking to put any further provisions in the bill to reflect those who choose to divorce and dissolve and then cohabit afterwards, because really they're in a very similar position to anybody else who decides to divorce or dissolve.
And finally, if I may please, relating to some evidence we've had from the Law Society regarding the excuse me, the wording of Section 4D, which is titled Application of under Section 4C, Death of a Spouse. The provisions to allow a person to continue to receive a gender recognition certificate if a spouse dies before the application is complete. And the suggestion that it doesn't cover all eventualities. Is that something the government would be prepared to look at if mentioned in the report?
Yes.
I think we're aware of the evidence from the Law Society and we are looking at that already, John, but again, you know, if the committee wants to comment on that, we'll take any comments very seriously.
Thanks very much indeed. Thank you.
Can I go back and ask the Cabinet Secretary why the current age of application for gender recognition for application to the Gender Recognition Panel is 18, when the age of consent for marriage and sexual activity is 16?
Well, he anticipated this question coming up because it is a serious question, and I want to give a fairly full explanation as to why we've made it 18 instead of 16. Before a person may apply to the Gender Recognition Panel, they have to produce evidence that they've been living full-time and exclusively in their acquired gender for a minimum period of 2 years. Now, that alone would suggest that you have to have the gap between the 16 and the 18 years. The age for applications was set at 18 in the Gender Recognition Act 2004 to reflect that persons are expected to live for 2 years in the acquired gender. 16 is an age when most adolescents can be expected to have reached sexual maturity. 16 is also the age of consent to sexual intercourse. Of course, some people mature quicker than others, but it may be difficult to vary the age limit from case to case. If we lowered the limit generally, there would also be practical concerns about how a child would be able to show that between the ages of 14 and 16, they had been living full-time and exclusively in their acquired gender. The panel looked to things like driver's licences, household bills and passports with the person's gender-appropriate name on it. Generally, we'd need some strong medical evidence to support any change in the age limit before we could agree to any moves to lower the age, and I have to say I would be extremely reluctant to do that for the reasons that I've outlined.
But there could be the possibility that the individual could have been living for 2 years prior to 16 and could get confirmation from possibly the school or the GP who could confirm the medication the individual was on?
Well, theoretically that's possible, but I think we have to be quite cautious, convener, on how we move forward on this, because very clearly I do think that I would tend to err here on the side of caution. You know, I think we've shown very clearly as a government and in this bill that we are very keen to ensure that transgender people have all the rights that they should have. But I do think we also have to strike a balance in this case, because there are clearly issues around, you know, the maturity of people of that age, their ability to show, particularly between the ages of 14 and 16, that they've been living in that way. And therefore I'm taking quite a cautious view on that. Now, if the committee disagrees with that, please say so in your report. We'll obviously listen to what the committee has to say, but I would need a fair bit of persuading of the need to change this particular part of the bill.
Okay, thank you.
Sorry.
Yep.
And the other point, yes, Simon had just reminded me, we didn't consult in this, and therefore I think it would raise issues if we amended that to 16.
Thank you. John Finney.
Thank you, Convener. It was remiss of me not to cover that in my own line of questioning, Cabinet Secretary. Cabinet Secretary, I understand that there are young people perhaps going to secondary school who will have their educational records changed on the gender on their educational records. Similarly with their medical records, that's my understanding, and indeed having spoken to an organisation assisting someone who, and the education authorities were delighted to have that assistance in respect of young people, it's perhaps the unfortunate association of the age and the term sex that's unhelpful here. Would you recognise that there are public bodies who are involved in recognising at the age of 12 and upwards, young people have chosen, made it a lifestyle choice?
No, I do recognise that, obviously, and you know, you mentioned the age of 12. You know, so do you pick 12? Do you pick 14? Do you pick 16? Do you pick 18? So my view is this is an area where I'm being quite cautious, because the law obviously will apply to everybody once you pass the law, and if you start to then allow waivers or variations for different age groups and what's allowed and what's not allowed, you end up in a very, very complex area. Indeed, and you would end up almost with an unmanageable part of the bill if you started to go down that road. So I think you either have to choose between 16 or 18, and our view is, for the reasons I've outlined, that 18 is appropriate, but we will listen to what the committee has to say. But bear in mind, we have not consulted on this. Yeah, I'll come to that because Siobhan.
Would there be any... Sorry, Cabinet Secretary, would there be any intention to consult on this aspect at any future point?
Well, in terms of this bill, you know, obviously we're moving towards stage 1 and then stage 2 and stage 3, so I don't see us having the ability to consult widely, but, you know, it may be that we could take powers to make a future change in secondary legislation by affirmative order would be a possibility, which would allow us to do it without primary legislation if there was a demand to do so.
Very much indeed.
Thank you. Can I bring in Marco Biaggi and then Siobhan McMahon?
Indeed, to follow on from John Finney, it's my understanding on this that the material change happens before the GRC, and that is simply the recognition of what has already happened, at which point, really, given that these material changes in life are happening to 14, 15-year-olds, as we know, it seems odd to withhold the recognition of that in formal legal terms. But I have another issue specifically that came out from one of our previous panels, which was a suggestion that and it was only a suggestion, by not allowing a 16-year-old person who is transgender to marry, whereas someone who's not transgender can marry at that age, we may be in law treating them less favourably and be open to a human rights challenge on that ground. Is that something the government has considered?
Well, everything in this bill has been, if you like, human rights law proofed. We don't believe any aspect of the bill would be successfully open to a challenge on human rights. But again, as I say, if the committee feels strongly in this matter and it feels that, you know, we haven't got this right, then we will listen to what the committee has to say. I am being admittedly cautious on this particular issue, and I think for good reason, but obviously if the committee suggests an alternative, we will listen to that very seriously.
And my understanding is that what we have in Scotland, in the UK, I mean, at the time it was seen as cutting edge. Clearly, other jurisdictions have now followed us in this area. And I was looking at the consultation and the document put out by the Republic of Ireland the other day. And I think very broadly what we have now is in line with other jurisdictions that have got similar procedures in place in respect of gender recognition. So I don't think we're out of line with what happens elsewhere.
Thank you. Siobhan McMahon.
Just a point of clarification. When you spoke about 14 and 16-year-olds, you used the term child. You also used the terms of maturity. I was just wondering if that was including the 16-year-olds at that time as well, or if you meant the lower ages.
I'm just using the definition that anyone under 16 is in law is regarded as a child.
Under 16, not 16.
Well,
Because what we're trying to get to is, obviously, we're trying to see if you would be willing to lower it to 16. Clearly, I've listened to your views on that and why you're cautious, but in my head, I don't understand how you can grant someone a vote, for instance, at 16, and the right to vote and to take part in democracy in that way, but not actually get the gender recognised in the way that they would want to.
Well, I do think there is a wider issue about the variation in age. I mean, you can get married at 16, but you can't drive a car till you're 17. The laws on drink and being able to access alcohol in a bar are 18. The laws on voting is, well, for the referendum, 16. I hope it will go to 16 more generally. So this bill is not trying to solve all of these problems. If we look at the general issue of the age of consent, the age for voting, the age for a driving licence, the age at which you can get married, the age at which you can join the army, the age at which you can go into illegal wars and get killed. All of those are variable. So this bill doesn't address those variations. It's trying to address...
No, it's a child and maturity, that's all. We've got that on record. Thank you very much.
In terms of what I said earlier, I was using the legal definition of a child, which is anyone under 16.
Does any other member have any other questions relating to that? No. Can we move on now to rights of religious bodies? And John Mason would like to ask questions.
Thank you, Convener. Yes, it was to move on to the area of, well, denominations, individual celebrants, that kind of thing. So, I mean, firstly, how confident is the government that a whole denomination, for example, Church of Scotland or the Catholic Church, would not be successfully challenged in court if they just point-blank refuse to take part in same-sex marriages? Because under the Equality Act, they appear to be providing a public function, and therefore it would appear that a same-sex couple could demand that they give them, celebrate a marriage for them.
I think two things to understand. First of all, is that the changes, both the contents of this bill and the changes to the Equality Act, which we've agreed with the UK government and which will be made before this act is implemented, John, makes it very clear and I think watertight legally, and that's the advice I've got, is that it's legally watertight in terms of any potential challenge under the Convention on Human Rights, European Convention on Human Rights legislation. Secondly, and Francesca will correct me, but I think I'm right in saying that the European Convention on Human Rights does not include a right to same-sex marriage. So it would be difficult to see under which part of the convention any challenge would be brought. So I think there's been a fair bit of scaremongering on this issue, quite frankly. The reality is we are absolutely sure that there is no prospect of a challenge under the European Convention on Human Rights in respect of this matter.
So you would actually say you're 100% sure or 90% sure, or would you like to put a figure on it?
I would say I'm as sure as anyone can ever be that there is no prospect of any successful challenge, particularly, and the UK government, by the way, shares that level of confidence.
I mean, I'm not questioning your intention to do this, both Scottish Government and UK Government. But I think there is concern, and we have both the Catholic Church and the Church of Scotland saying that they might have to pull out of marriages altogether because the risk is so great. We've had legal opinion on both sides on this, so I do think there's legal opinion on both sides. And I mean, I agree that the European courts are not saying there is a right to same-sex marriage, but if we create a right for same-sex marriage, then what is to stop somebody challenging that and saying, you, the Church of Scotland, you, the Catholic Church, are discriminating against me?
So, I mean, the key thing with the European Convention of Human Rights also gives rights to religious organisations and to celebrants as well. So our view very clearly, and it's a view shared by the Lord Advocate in Scotland and by the senior law officers in the UK, is that there is no realistic prospect of a successful challenge to this aspect of the legislation.
Except that when it came to the adoption agencies, especially Catholic adoption agencies, strong assurances were given by the government that this was only permissive and agencies were being permitted to, for same-sex couples to adopt. But that then fairly swiftly moved on to it became compulsory, and we're now losing agencies who do not want to take part in that. So if the same logic happened to marriage, it could become compulsory.
There's two different scenarios, and I think you can't compare apples and oranges, quite frankly, John. The solemnisation of marriage is a function carried out by churches. It's at the heart of what churches do, and the work is carried out by religious celebrants. It's plain that protection can and should be provided to protect denominations and celebrants, and quite frankly, it is not the same situation as was the case in terms of the adoption law.
Explain why there's a difference?
I'll get the lawyers to explain exactly what the legal difference is.
I think the Scottish Government's position is that we are satisfied that the protections put in place in this bill are robust. The European Convention of Human Rights permits a wide margin of appreciation when it comes to balancing the rights of different bodies or different persons, which is what this bill is seeking to do. The Scottish Government considers it's proportionate and reasonable to pursue a policy which would mean that not every couple will be permitted to have this marriage ceremony of their religious or belief choice, and the justification for that is to take into account the religious views and Article 9 rights of religious bodies and celebrants. We're satisfied that that's a proportionate and reasonable approach.
I mean, yes, yes.
Supplement that a wee bit.
The other point is quite simple, really, that there isn't any public money going into churches to solemnise marriages. As I understand the position with an adoption agency, when the adoption agency is successful in placing a child with a couple, there will be some public money paid by the local authority to reflect that, and a public service generally has to be available to all. Well, in this case, we're not providing any funding to the churches to solemnise marriages, and indeed, if we offered money to the churches to solemnise marriages, they would run the other way very quickly.
Although, like a chauffeur or a photographer would not be getting public money, but they would be required, they would be counted as a public service, wouldn't they?
Service, yes.
Yes, I'm not quite sure I understand why they are different from a church.
The church is carrying out a religious function, which isn't true of the photographer. The church is carrying out a religious function and is entitled to rely on its rights to say what religious service it is providing. That's not true of the photographer, which is providing a civil function.
Slightly different angle. If a denomination as a whole, the Quakers were mentioned, opts in, but an individual celebrant wants to opt out, is that not the government interfering within that religious organisation?
Well, as I said, this is about freedom and rights, and if an individual celebrant doesn't want to opt in, then the individual celebrant has that right.
It was suggested to us by some of the legal opinion that was effectively the state interfering in the internal workings, because it was stopping the denomination controlling its own members?
No, not at all. I mean, at the end of the day, we have got to have a balance between the rights of the individual and the rights of the state. It's not our wish at all to interfere at all in the internal workings of any religious organisation. But obviously, every individual has certain rights, and if a celebrant decides that they do not wish to participate in a same-sex marriage, then they have the right, as far as we are concerned. Now, if within the church organisation, they may decide that if a celebrant takes that position, then they no longer wish to have that, or a minister or a rabbi or a priest takes that position. They may then decide that they really don't want them to, be taking part in a whole host of things. That'll be an entirely matter for the religious organisation to decide. But as far as the state is concerned, the individual celebrant has the right not to participate.
And the other point possibly to mention, Mr Mason, is that what we have in the bill is in line with what's outlined in a number of other jurisdictions as well. In the consultation paper, the second consultation paper, I think possibly the first as well, we quoted the Norwegian Marriage Act, which lays down that a clerical solemniser can refuse to solemnise a marriage. There was discussion in this committee over the past few weeks about the position in Denmark, where again the individual celebrant can choose not to take part in marriage, even though the Church of Denmark is taking place in marriage. Clearly it's a position in England as well under the UK Act. And in addition, there's precedents in other areas as well. For example, in England, generally there's an obligation on Church of England celebrants to marry people within their parish. But that obligation is specifically disapplied in relation to divorce, for example. So there are precedents in other areas as well as in relation to same-sex marriage in other jurisdictions.
Still to see if that will actually stand up in court.
But the other jurisdictions have been in place for some time, and there's no sign of any celebrant being forced to solemnise a same-sex marriage against his will in jurisdictions subject to the Convention.
And I wonder if you would accept, Minister, that when cases go to court, the courts within the Equality Act, although it doesn't have a hierarchy of protected characteristics, in practice the courts tend to put sexual orientation and other protected characteristics above religion and belief.
I don't know if I would agree with that generalisation. I think it's always very difficult to summarise what the courts do in terms of hierarchy. I think sometimes, John, it depends on the judge. But in terms of the law, and it's the law we're addressing here this morning, in terms of the law, we are absolutely confident that there is no serious prospect of any successful challenge to this bill.
The final point I just wanted to make was the Jewish community raised the issue that they have actually different branches within the Jewish community and would find it difficult to, as a whole, be kind of in or out or whatever. Would you be open to, I don't know if you've read their evidence, but I don't know if would you be open to some kind of amendments along the lines they suggested?
We have read the evidence and we'd have a look at some of the detailed points that they're raising, yes.
That's great.
The principle remains the same. We're not, people have to opt in, and organisations have to opt in.
On the same subject, I'd like to bring in Alex Johnson and then Marco Biaggia.
Very briefly, and it refers to things that you've said in answers to the previous questions. You've said that protection from prosecution under European legislation would be based on the fact that the European legislation does not grant the right to same-sex marriage. And you just used the line there that you saw no serious chance of a successful challenge. Is that the summary of the views you expressed?
Well, it's not a view. I mean, it's a fact that the European Convention on Human Rights does not include any right to same-sex marriage.
When I spoke to you earlier about this, you defined the right to same-sex marriage in your view and in the view of the government as an equality issue. And you defined the inclusion of, or the existence of same-sex marriage as something that you wish to include in Scottish law as a result of your desire to pursue your definition of equality. Is it therefore unusual for European human rights legislation to entrench something which you see as an inequality?
Well, they may well do, but that would require, obviously, the agreement of all the signatories to the European Convention on Human Rights. And as you know, at the moment, there are proposals circulating within the UK government to withdraw from the European Convention on Human Rights. So one cannot entirely predict the future because it will depend on whether we remain first of all, as part of the UK state, and if we do remain part of the UK state, whether the UK state will remain signed up to the European Convention on Human Rights. But our view, I mean, and my view is the same as David Cameron's and Maria Miller's, and that is, and our law officers' view, and obviously we take our advice from the senior law officers, and every law officer in the UK, I think, is on record as saying that they do not believe there is a serious, any prospect of a serious challenge to this legislation or the UK equivalent legislation.
I accept that view, but to summarise the position, we've now got to the stage where ECHR effectively entrenches something that you have yourself defined as an inequality. What's the prospect of European law being changed? Are there precedents for European law being changed where there was a difference, a change in perception of what constitutes equality?
I'm not qualified to answer that question. I don't know if the lawyers can, Alec, but my view would be, I have to say, if the European Convention on Human Rights is changed, particularly given the point just made by Simon about the number of jurisdictions now in Europe, which have got very similar legislation, some of them quite long-standing legislation, if the European Convention on Human Rights was changed, I think the likelihood is it would be changed to entrench the provisions in this bill rather than to mount a challenge to the fundamental principle of the same-sex marriage legislation.
But if European law if European law was to change so that there was a presumption that it would grant the right to same-sex marriage, does that remove the protections that you have assumed will exist for the Scottish legislation?
Yes, next year, because, for example, I would argue strongly that if there was a change of the type that you're outlining, my view is it would also have to be built in simultaneously, exactly what we're doing in this legislation, what your colleagues have done south of the border. There have to be concomitant safeguards for those religious bodies and celebrants who do not wish to participate.
And I think the other point I'd like to make, possibly, Mr Johnson, if I may, is that clearly this jurisdiction is not unique in having this type of debate. There's a very similar debate going on in other jurisdictions which are party to the European Convention as well. So as the Cabinet Secretary was saying, it's unlikely, I would have thought, the European Convention would change to say you've got to do same-sex marriage, you're forced to do same-sex marriage, because plenty of other religious bodies in other jurisdictions are having exactly the same points as religious bodies are making in Scotland.
Don't believe that there is a prospect for a change in another jurisdiction to remove the protections which you assume they currently grant towards Scottish religious institutions?
My view is all the signatories to the European Convention on Human Rights, there is nothing in the Convention at the moment which gives anyone the right to same-sex marriage. It doesn't cover it. I mean, it's like, I'll give you a parallel, actually, Alec. I think at the time when the convention was being drawn up, same-sex marriage was not an issue. It's in the same way that in the Scottish Parliament, climate change did not become a reserved matter, because at the time the Scotland Act was written, nobody had heard of climate change. So there is no reference in the convention to the issue of same-sex marriage. My view is the signatories to the European Convention on Human Rights, if there was a desire and agreement, and that's a big, big if, to change the European Convention on Human Rights, my own view would be to change it to accommodate the kind of legislation, the balanced legislation that is in this bill and in the UK bill. It's not going to change it to stop people, to prevent people having same-sex marriages.
The functionality of the bill is dependent on the status quo in Europe. The functionality of the bill as presented is dependent.
I mean, the question is there a prospect of a serious legal challenge under the European Convention to the provision of this bill? And the clear legal evidence, both north and south of the border, is no, there is no serious prospect of any successful challenge to the provisions in this bill or the UK equivalent bill.
The ECHR as it currently stands?
Yes.
As it currently stands?
Absolutely. I now move on to Marco Biaggia. We're running out of time. And then Siobhan McMahon.
Thank you. Just very briefly, there have been some amendments that have been suggested in this area in written submissions to the committee. One set came from the Church of Scotland, I believe, with regard to a wording change about performing marriages and having marriages recognised. Is that something, this might be a Simon Stockwell question, is this something that the government has looked at and is pondering?
Thank you, Cabinet Secretary. We actually met the Church of Scotland a couple of days ago to talk about this particular point and to talk about some other issues with them as well, including the civil partnership review that the Cabinet Secretary mentioned earlier. As I understand where the Church of Scotland are coming from, in essence, they want the Marriage Scotland Act 1977 to be amended so that it's clear that religious celebrants are not acting as agents of the state, that they are acting on their own behalf. The difficulty I think we have with the proposed amendment, and I said this to the Church of Scotland, is that we're not sure that the proposed amendment makes much difference in practice, really, because in practice what they are suggesting with that particular amendment is that we would still recognise those services. So the services will be carried out by religious bodies, religious celebrants as they are now, and they'd be recognised by the state and the rights and responsibilities would flow. So we tended to think that to an extent what they're proposing is really just a drafting change rather than a change of substance. Now, we'll certainly consider it further, and I suggested the Cabinet Secretary might want to write to the Church of Scotland once we've considered it further. But when we looked at it, our view was it probably didn't make much practical difference.
We heard a suggestion in a submission that, as well as the freedom of speech provision in the bill, there would be benefit to including freedom of speech provisions in specific other acts, namely public order legislation, I believe the Threatening Behaviour Communications Act as well. Is that something the government considers necessary, or do you consider that the section in the bill covering freedom of speech is sufficient?
Well, I'm just dealing with this bill. I mean, any suggestion and further amendments to other bills, for example, about football matches or for anything like that, the proposals would have to be made to my colleagues. I don't have any ministerial responsibility for that area of policy.
Thank you. Can I now bring Siobhan McMahon into the questioning?
Just on the issue of freedom of speech, or rather the guidance that was issued by the Lord Advocate regarding this bill, we heard an evidence from Ephraim Browski, who said that, and I'll just quote, that they've commented that it is a concern that, for example, the Lord Advocate produces guidance on the prosecution of people for expressing their opposition to the proposal in a particularly strong manner, but not guidance on the prosecution of people who express their support for it. Now, clearly, social media has been the major tool for this. We're all aware of different sides of the debate, obviously, using social media as a tool for what can only be described, frankly, as abhorrent comments, but particularly if you express a view against the bill. So I'm just wondering if you get any view of addressing the guidelines at the moment, or speaking to the Lord Advocate and how we can get that stronger.
I think the Lord Advocate's guidance is very balanced and very fair. I think there's a precedent for this, Siobhan, because, you know, I was in the Parliament at the time of the controversy over Section 28, or Section 2.8, and at that time the then Lord Advocate published guidance of a very similar nature, resulting from the change in legislation proposed by Wendy Alexander. And, you know, it's only one page, the guidance, and it's really to try to protect freedom of speech on all sides, provided people behave reasonably and are not, you know, stirring up and, you know, hatred or antagonism and the kind of things that we would nobody on any side of the argument would want to see. And that's the purpose of the Lord Advocate's guidance. I have to say my own view is that the Lord Advocate's guidance, and of course he doesn't consult in his guidance. I mean, I was not consulted and should not be consulted on the Lord Advocate's guidance, because it would be entirely wrong for this to be politically motivated. So any amendments to that guidance would need to be considered by the Lord Advocate. My own view is that the Lord Advocate has produced a very proportionate, very fair, very balanced and very practical guidance on this issue.
And on a slightly different topic, has the Scottish Government included in the financial memorandum to the bill the cost of the public purse associated with any decision by the Church of Scotland, for instance, or the Catholic Church or any other faith community, to stop performing the civil law aspects of weddings? Is that in the financial memorandum?
The financial memorandum of any bill relates to the impact on the public purse and the public purse only. So no financial memorandum would estimate the impact on, you know, other institutions in terms of estimating the costs. I mean, obviously, it depends how those
I'm asking is, we've heard an evidence from all the churches that they may have to go to like another European country, so for instance France, where you have to have the civil ceremony and a religious one. So clearly that would put the public part of it, the cost would have to go up presumably. So should that be included now that we've got evidence of that?
I'd say there's nothing in this bill that would force the churches either to abandon carrying out marriages or to do it in the way they do it in France. There's nothing in this bill that would force the churches to do that. It's obviously a matter for the churches if they decide to do that. If there is a cost involved as a result of their decision, that's their affair, not mine.
It would be your cost. It would be to the public purse. So I understand it's their decision, but you would have to come up with the cost for it.
Can I answer that? it's not covered in the financial memorandum, but actually civil marriage ceremonies are done on a cost recovery basis.
Yes.
So the cost falls on the couple. So if there was an obligation to have a civil marriage ceremony, then the couple would have to pay for that. And clearly it would be a matter for them to decide whether or not they then wished a blessing in the church.
John Mason.
On the specific point about the Lord Advocate's guidance, we did have legal opinion that guidance does not really carry very much weight. Can you confirm that's the case?
I would strongly dispute that. The idea that the Chief Prosecutor's opinion does not carry any weight with the prosecution service, I think, is absurd.
Thank you, Cabinet Secretary. Moving on to public sector workers, I'd like to bring in Christian Allard.
Thank you very much, Commissioner. Yes, we had a lot of discussion during the panels, during the evidence, when we took evidence, particularly on public sector workers, and particularly on the interaction, and we talked about that already this morning, about the interaction between different legislation. There are different views. There are, of course, some religious group suggested that in human rights terms there are hierarchy where issues of gender would trump issues of religion. Others took a different views and opposite views. Others took no views at all. And we have the Law Society, where the submission as well expressing uncertainty regarding how Article 14 rights will interact with the public sector equality duties contained in Section 149 of the Equality Act. Again, we talked about earlier on, there is a lot of discussion about the Section 149 of the Equality Act. What I would like to know, Cabinet Secretary, is whether it would consider you would consider allowing the principle of reasonable accommodation that some of our witnesses ask in regards to public sector workers providing a service, and if yes, how this may be conducted in rural areas.
As I understand the question, this is about the rights of public sector workers to object to the principles of the bill, not having to carry out their duties. I mean, actually, you know, in some cases this already happens where some people may have had an objection in the past to a particular aspect of a particular type of ceremony, and our view is that there's no big issue here, quite frankly, because clearly, I mean, I think mainly we're talking about registrars and the ability of registrars to carry out their work, and an opt-out, the opt-out issue. I think there's a big distinction between a publicly employed registrar and a celebrant in a church, because the public sector registrar is there to carry out a public duty and is employed to do so. Having said that, though, if a public sector worker has specific concerns, as they should about anything, it should be raised with their employer in the first instance. And I have to say the registration of civil partnerships by civil registrars has worked well. If you take the last 8 years since the legislation was introduced, there have been 4,800 civil partnerships registered in Scotland. And there's no reason, I don't think, to expect the solemnisation of same-sex marriage by civil registrars will not work as well. Now, I've no doubt that some of those civil registrars had concerns and maybe didn't agree entirely with the civil partnership legislation, but it has not presented a problem. The civil registers, as you know, in Scotland are employed by local authorities. It's for each authority to decide how best to provide services for the registration of marriage, and we would expect the local authority to handle with sensitivity a registrar who objected to same-sex marriage or to civil partnership on the ground of religion or belief. And we've had no representation whatsoever from local authorities asking for an opt-out in terms of the responsibilities of civil registrars. So, to be quite honest, we believe this is a bit of a red herring. We don't see any problem here. I think common sense should just prevail, as it has done for the last 8 years in relation to civil partnerships.
You don't see any views of accommodating?
The local authority, as the employer, we're always trying to accommodate. Where a person who's a civil registrar, if they've got a religious or belief objection to same-sex marriage, then I think in relation to the local authority employing them, they will come to some kind of appropriate accommodation on the matter. Common sense just has to prevail.
Thank you very much for this. What is the scope for conflict between Article 9 rights of thought, conscience and religions and the public authorities' public sector equality duties?
I think this is basically the same area, Christian.
What I'm talking about now is the conflict between maybe the different legislations.
I don't think there is, because the public sector duty is on the authority. It's not on the individual employed by the authority. The duty is on the authority, not on the employees of the authority. And therefore, I don't see any conflict.
So you don't think that the equity duties would take precedence over public sector employees' own Article 9 and 10 rights to express and act on their own views?
Public sector duties are very clear, and that is that the authority, in this case the local authority, has the public sector duty. The employee does not have, as an individual, a public sector duty. As an employee, they do have responsibilities, but if there's any clash in terms of belief or religious belief or non-religious but nevertheless conscientious objection, that is for the employer and the employee to work out between them. And obviously in working it out, the employer has to be very cognizant of the legislative framework within which they're operating. And in this case, this bill, when enacted, would be part of that consideration. The Equality Act would be part of that consideration. The public sector duty would be clearly part of that consideration. Our rules on how the public sector duty is exercised, because although we don't define the public sector duty, that's a reserved matter, we define how the public sector duty is carried out in Scotland, that's a devolved matter, and also Convention of Human Rights and employment legislation. All of that comes into the mix. But we don't see any conflict in the legislation, and we think, you know, there's precedent here, for example, with the civil partnerships, where that has been handled very sensitively and with a great deal of common sense, and as I say, it has not resulted in any pressure in relation to this legislation or indeed to the civil partnership legislation in terms of employees of local authorities carrying out their duties.
Thank you very much.
On the same subject, I'd like to bring in John Mason and then Marco Biaggi.
Thank you very much, Convener. I mean, you say that you hope common sense would prevail on that issue, but I mean, we have a legal case, albeit not in Scotland, with Lillian Ladelli, where the local authority did insist that she take part. And I mean, you said that the employers, i.e. the local authorities, have not made any representations on this. Well, of course they won't, because we're talking about protecting their employees from them. So they're not going to make a representation. I mean, on another controversial issue, which is abortion, we have specifically in the legislation protection for employees to either take part or not take part. And that seems reasonable to me. Would it be possible to have that in this legislation?
Well, I think first of all, can I say, in terms, there's been a lot of questions on the Convention on Human Rights, and I think the key point about the Lillian Ladelle case is that the European Court of Human Rights did not find that there had been a violation of Ms Ladelle's human rights, and therefore this bill is in line with that decision. And, you know, there's been a big play made about the role of the European Convention on Human Rights. So in terms of an employee's human rights, according to the European Court, these were not breached in that case.
So they didn't protect her, and you don't want to protect her?
Well, I don't think you can say that, John. I mean, the European Court, which is the protector of human rights for all of us, having heard the case, made the decision that her human rights had not been violated. And that's not something that I'm qualified to question or to undermine in any way. And I think the key thing here is that the human rights of everybody, including employees, has to be protected. In that case, the court said her human rights had not been breached. Now, you may disagree with the court's decision.
Certainly do.
But I have to legislate according to what the framework of law is, and part of the framework of law is this particular case now.
Then that you could put in a clause in the law that would give added protection.
I don't think it's necessary, quite frankly. I don't see a big issue here at all, and I don't think, you know, the local authorities, if I'd had representations from local authorities which said there is a big issue here and you need to address it in the legislation, I would listen to it. I haven't had any such representation. I haven't had any representation, I think I'm right in saying, from any registrar in Scotland on the matter. So again, it's a red herring. It's a red herring.
Obiaji.
You slightly preempted my question there. I was wondering if you had had formal contact with the representative body for registrars in Scotland, I believe it's AROS, and whether they had given a view on this particular issue.
I met registrars. The Registrar General's office kindly organised a seminar for me with registrars from across most Scottish local authorities a year or so now, and we did discuss this particular issue with them, and it's as the Cabinet Secretary said, there was no desire around the room for any legislative opt-out, and they commented, as the Cabinet Secretary has mentioned, that when they have somebody who's against civil partnerships, then they try and ensure that that person is moved to other duties within the Registrar's office.
Common sense prevails.
Do members have any other questions they'd like to ask the Cabinet Secretary? No. I've just got 2 points, two questions to ask you just to finish. One is regards reset. It's currently a defence in Scots law that a wife is not guilty of criminal charge of reset of goods which have been stolen by her husband. This will not be available to a woman in a same-sex marriage. It would appear that this provision could be discriminatory, but the Scottish Government, I believe, are you considering this law?
I'll let Simon answer that very, very specific question, Convener.
Yes. Our understanding is the defence hasn't been used for a number of years. It's about 20 years, we think, since the defence was last used. It is an odd defence, and it reflects an antiquated view of marriage and the position of men and women in society. And having discussed the matter with our criminal justice colleagues, we intend to recommend to the Cabinet Secretary that the Government might lodge an amendment at stage 2 to repeal the defence altogether.
This may be the same answer, but I'm asking it anyway. According to Linda Towers, the current law on impotence was drafted with same-sex marriage in mind. If proved, the marriage could be declared void, which could have a different effect from marriage ending in divorce. It could be argued that since the provision clarifies that this rule of law will only apply to different sex couples, then it could be discriminatory.
This is a different answer, actually, this one. We did discuss this one in the policy memorandum. Similarly, the ground of curable and permanent impotency for voiding a marriage is certainly antiquated and not often used in Scotland. And we have thought in the past about whether there's any scope for removing it altogether from Scots law. And we have had some comments to the effect that we should remove it from Scots law. But equally, some people have suggested that this particular concept is useful in certain circumstances, particularly for those who might wish to enter into another marriage but might not wish to get divorced because they've got religious objections to divorce. So given that there is that particular religious aspect to this issue in relation to impotency, we intend to make no change and leave the provisions in the bill as they stand.
Having said that, it's the type of issue that the Law Commission might give longer-term consideration to, and it might be that the committee might want to recommend to the Cabinet Secretary for Justice to refer the matter to the Law Commission.
I'm sure the Law Commission would welcome a look at it. I used to sponsor the Law Commission. I know it's the sort of thing they very much enjoy doing.
Compliment, let me emphasise before we get letters from the Law Commission.
Can I just check that members have no more questions to ask before ending the session? Okay. Can I now invite the Cabinet Secretary to give closing remarks?
Thank you very much indeed, Convener. I mean, we've covered a lot of very specific and technical issues. Can I say, just repeat what I said at the beginning, I see this bill about rectifying an anomaly in terms of the quality of treatment of people who at the moment are not allowed to marry in Scotland. At the same time, I think we've made it absolutely clear we are determined to protect the rights, particularly of church organisations and celebrants, in the way that I've described, in the way that's described in this legislation and in the amendments to the Equality Act. And I think Scotland will be a better place when we pass this bill.
Thank you very much, Cabinet Secretary, and thank again for your contribution. That concludes the public part of today's meeting. Our next meeting will take place on Thursday, the 10th of October, and will include evidence in the Scottish Government's draft budget 2014-15. I will now suspend the meeting for the committee to move into private session.